Well, this is cause number 329-106, cause number 329-188. Both cases are styled the state of Texas versus Dan Shelton III. We have Mr. Shelton appearing via Zoom with his attorney, Mr. Langston Adams, who is also appearing via Zoom. And in cause number 329-106, there was a motion for psychiatric examination or psychiatric evaluation that was filed. The court held an informal inquiry and granted the motion. Dr. Prapam was ordered to do the psychiatric exam evaluation. The court has a copy of the psychiatric evaluation. Mr. Adams, do you have a copy? Or did you receive a copy of that evaluation?
I got it.
And Mr. Boyd, did you receive a copy of that evaluation?
Yes, Your Honor.
Now, based on the this evaluation, Mr. Adams, do you have to the findings, conclusions, and recommendations that has been made in this evaluation?
No, I don't have any objections to it.
And Mr. Boyd, do you have any objections to the findings, conclusions, and recommendations in this evaluation?
No objections, Your Honor.
Okay, now, is either side requesting a jury trial in this case? In the incompetency trial, is anybody requesting a jury trial or anything?
No, not that I'm aware of.
Okay.
No, Your Honor.
Okay, so pursuant to Article 46B.054, the courts find that first of all, the court is going to take judicial notice of the findings, conclusions, and recommendations in the psychiatric evaluation that was conducted by Dr. Krapon. Therefore, the court finds that the evidence exists to support a finding of incompetency for the defendant to stand trial. And the court finds that counsels for each, for the state as well as the defense have agreed that the defendant is incompetent to stand trial. And the defendant, Dan Shelton, having been charged by information in connection with the above entitled and numbered cause in the following case as 329-106 for the criminal offense of criminal trespass, which is a Class B misdemeanor. On this day is being called for trial. The state appeared via Zoom by assistance of District Attorney Daniel Boyd. The defense appeared via Zoom by Attorney Langston Adams and announced ready. The defendant incompetent to stand trial has been raised in advance of trial on the merits pursuant to Article 46B, the Texas Code of Criminal Procedure. The court finds that the attorney had previously submitted the order appointing expert to examine the defendant, which was signed and approved pursuant to 46B.005 and 46B.021 of the Texas Code of Criminal Procedure. The court further finds that the court-appointed expert is qualified under Article 46B.022, Texas Code of Criminal Procedure, to evaluate the defendant on the issue of competency. That said expert considered the factors regarding competency detailed in Article 46B.024 of Texas Code of Criminal Procedure, and that said expert has provided the court with a detailed report of their findings and opinions pursuant to Article 46B.025 in a timely manner. On today's date, which is July 15th of 2021, the court conducted a hearing in the defendant's pending criminal case related to Dr. Crapon's report, and appearing for the defendant via Zoom was his appointed counsel, Mr. Langston Adams, and Daniel Boyd appeared via Zoom for the state. The defendant also appeared via Zoom. Neither party objected to the contents of Dr. Crapon's report, nor to his conclusion that applicant was presently mentally ill and incompetent to stand trial because of said mental illness. The court accepts Dr. Crapon's report as credible and adopts it as part of its own factual findings in the competency matter. The court finds that all necessary criteria have been met under Article 46B, Subchapter C, the Texas Code of Criminal Procedure, and further finds that the defendant is incompetent, to wit, does not have the sufficient present capacity to consult with his attorney with a reasonable degree of rational understanding, or a rational as well as a factual understanding of the findings against him. It is therefore ordered, adjudged, and decreed by the court that the said defendant is incompetent to stand trial in misdemeanor case. It is further ordered by the court that said defendant's inpatient commitment be limited to a period not to exceed 60 days as required under Article 46B.073B1, Texas Code of Criminal Procedure. Court further finds that the defendant is not charged with an offense listed in Article 17.032A, Texas Code of Criminal Procedure. Court finds that said defendant's inpatient commitment does not require that he be committed to a maximum security unit. It is therefore ordered by this court that the Sheriff of Jefferson County, Texas, take the defendant into custody and deliver him to a mental hospital or other inpatient or residential facility, and that the said defendant be confined therein in accordance with this judgment for further examination and treatment toward the specific objectives of obtaining competency to stand trial. And on today's date, Judge Terrence L. Holmes presiding. And this will conclude this hearing on both cases. So at this time, Mr. Shelton, you can follow the bailiff. You're free to go follow the bailiff and have a blessed day. And okay, Mr. Adams, this will conclude. Will this conclude all your cases?
It's all my cases.
Okay. This will conclude all your cases. You're free to go and you have a blessed day as well.
All right, you too.